Big day today for Andrew Gillum, the former mayor of Tallahassee and former gubernatorial candidate against, of course, Ron DeSantis. Almost won that race. Remember that? What was it, 2018? Lost by 0.5%. And then things turned south for him. It's my opinion that Andrew Gillum has sort of the same character flaws that a Michael White has. So they're talking about maybe he'll even run again for mayor, and I'm sure he'll win if he does. The thing about a guy like Andrew Gillum, sadly, really, is that he has character flaws that are just, I mean, you should see the guy's wreck. But the Fed said they're dropping all charges against him, 17 of them. 2 weeks ago, he was found not guilty to lying to the FBI. The other 17 charges having to do with a nonprofit and splitting money from the nonprofit with his campaign manager. It was a mess. But U.S. Attorney Jason Cootie says we're just dismiss them all. We're not going to retry Andrew Gillum. Instead, they're going to focus all of their attention on James Finch. Now, I'm going to show you tonight exactly what law the feds had to use to even try James Finch, why they had to rewrite the indictment 4 times, the new theory of liability they had to come up with no evidence, called 18 U.S. Code 666, that does not require quid pro quo for bribery because there was none. You're not going to believe what I'm going to show you about this. I've dug it up. About half of the country, the feds can't even prosecute somebody like this. But in this particular region, they can. It's quite amazing. I'll also tell you that if I were a betting man, I'll bet you that they'll delay this all the way until next year, the retrial. I'll bet you. And I'll explain that too. First, however, I want to show you what I wrote about the big news today, the dismissal of all counts against Andrew Gillum. But tomorrow is Super Tuesday in Bay County, Super Tuesday. The runoff election in Panama City is huge. You've got Doc Rowan running against the incumbent Greg Brudnicki. You've got Lynn Haven has a chance to elect Brian Gray. Don't turn Lynn Haven into a giant HOA. Vote for Gray. That's also a runoff election. But I want to start real quick. I want to show you, if you're in Panama City, you're voting in Panama City. This is a paid campaign ad, but you have a chance to make a difference tomorrow. You got to go to City Hall on Harrison Avenue to vote. Doc Rowan is running for mayor of Panama City. The city wants to spend $170 million to build a new civic center. They could have restored it for $12 million. Why are they so determined to spend more than $150 million than they should? And they want to shut down the boat ramp in the marina. If they have their way, generations of boaters and fishermen would become second-class citizens. It's time for a mayor who puts you first, rather than the big developers. Vote for Doc Rowan on or before April 18th. Really have a chance there. All right, let's take a look at this. All right, here's the U.S. Attorney's Office here, the ones who are prosecuting James Finch, Margo Anderson, and that's U.S. Attorney Jason Cootie. And here's what I wrote earlier today. U.S. Attorney Jason Cootie drops all 17 charges against Andrew Gillum after the jury delivered a hung jury 2 weeks ago. They are still determined, the feds, U.S. Attorney Cootie, to put James Finch in prison for the rest of his life over 2 absurd counts of bribery with a $5,000 check that he wrote back in 2017. His hung jury was 8 weeks ago. I wouldn't be surprised if they push Finch's second trial to early next year. And part of that has to do with James Finch changing his defense team But still, that's what I unfortunately think is going to happen. Delay, 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 false charge after false charge, delay, 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 repeat. They're obsessed with Finch as Sheriff Tommy Ford works with the FBI to deflect attention away from the real criminals who robbed Bay County after Hurricane Michael. More than $300, maybe $400 million of FEMA money flowed through the county. Kickbacks, crooked deals, delayed cleanups. God, it was unbelievable. And they know all about it. Sheriff Ford and the FBI know all about it. But it's in my opinion, it's very much like the Epstein Island client list, right? The people who are who got the kickbacks, who got the generators, who pushed through fake deals to help their friends. Oh my God, all of that. It just so happens that the people on that list are closely aligned with the people investigating the FEMA fraud. Very similar. This helps the St. Joe Company, by the way, which is owned by BlackRock and other hedge fund companies. The St. Joe Company donated $180,000 about 6 weeks ago to Sheriff Ford's office, which the sheriff's office says will be used to purchase defibrillators for every patrol vehicle. St. Joe and its politicians have big, big protection. Do you think it's likely that the sheriff's office will keep a close eye on the St. Joe Company if the St. Joe Company is donating a couple $100,000 every now and then to the sheriff's office? It's hard to imagine. But that happened today. And I want to show you what law, what federal code the prosecutors are using in order to even try James Finch at all. Are you ready for this? I'm going to lay it out for you. Okay. Here it is. U.S. Code 18 U.S. Code. That is the bribery, kind of the bribery public corruption code. Section 666 targets political corruption in federally funded programs. It extended federal reach into state and local governments, especially for bribery and illegal gratuities. Federal jurisdiction kicks in when a state or local government receives at least $10,000 in a one-year period from the federal government, and when at least $5,000 is used to corruptly influence a government act. That is when the feds say, this is our jurisdiction now. It has to meet that minimum threshold. And of course, it does. It's a $5,000 check. It's the minimum threshold for the federal government to kick in. There are two crucial elements in order to get a conviction on Section 666 that targets federal programs corruption. One, intent to influence. Finch's defense, by the way, is how could I have intended to influence former Commissioner Antonius Barnes after July of 2017 for the financing on the 17th Street ditch when that was already voted on at least 6 months prior? How could I have intended to do that? And the giving of at least $5,000 be done corruptly. Both of those have to be met, not one or the other. Both must be met for a conviction. About half of the U.S. courts of appeals require quid pro quo for bribery conviction under Section 666. The rest of the U.S. courts of appeals don't require quid pro quo for bribery. A wink and a nod is enough. James Finch is being tried under the Northern District of Florida, which falls under the 11th Circuit Court of Appeals. It does not require, the 11th Circuit does not require a quid pro quo for a conviction. U.S. Attorney Jason Cootie rewrote the indictment against Finch for the third time. There's been 4 of them, in order to apply Section 666 in this case, since there was no evidence of quid pro quo. They couldn't do it just under U.S. Code 18. So they're going for the wink and the nod evidence. The $5,000 check that Finch wrote to the former commissioner as a business loan that went into the commissioner's business bank account is the lowest possible amount to fall under federal jurisdiction. All right. So I want to go over a little bit, why did Section 666, what is the purpose of it? When did it come about? Well, let me show you. I'm going to show you a few things, a couple of them from the U.S. Justice Department. And I want to kind of show you why some circuits require quid pro quo while others don't. All right. Let's take a look at this first. This is from the U.S. Justice Department. This is the reason that this even exists. To protect the integrity of the vast sums of money, like FEMA money, for example, distributed through federal programs, Congress enacted 18 U.S. Code Section 666. This section is designed to facilitate the prosecution of persons who steal money or otherwise divert property or services from state and local governments or private organizations, for example, universities, foundations, and business operations that receive large amounts of federal funds. Now, remember what Finch did. Finch is being charged with bribing Antonius Barnes with his own $5,000 check in order to finance the city of Lynn Haven with his own money. He didn't steal federal money. The subsection, okay, so we're getting into some weeds here. Under prior law, third paragraph, with few exceptions, thefts from such government organizations could be prosecuted only under the general theft statute, Code 18. And basically what would happen is defendants would say, look, the money was commingled. You can't prove that, I got any federal money. So that's why U.S. Code 666 came about. I'll show you. Also from the Justice Department. Here's the scope of how this section's supposed to be applied. Okay, now this is really important because the Justice Department itself requires the U.S. attorney's offices that are part of the Justice Department to use discretion, right? The purpose of the law is to prevent the theft of large sums of federal money that is received by local governments. In this case, I don't see any money, quite frankly. Yes, Lynn Haven got more than $10,000 in a one-year period, but this is Finch's own money that he loaned. How much federal money has been used to prosecute Finch to reach as far as they're reaching to apply this flimsy application of this law, of this section? If this whole section is to protect federal money, then this U.S. Attorney's Office is certainly spending more federal money than anybody could imagine saying was stolen or diverted, right? I mean, that is irrefutable. So here we go. Look at this from the Justice Department now, what I'm showing you. In some cases, local prosecutors will have both a strong incentive, like our own local prosecutor here, State Attorney Larry Bassford. they'll have a strong incentive and the ability to prosecute crimes involving local programs receiving federal funding. The advisability of a federal prosecution like this one under this should be carefully weighed against the likelihood that state prosecution will be sufficient to protect federal interests. In other words, we're trying to protect federal money here. I mean, the country's more than $31 trillion in debt. The federal government's borrowing like $8 million a minute. It's the purpose of this law, of this section of the U.S. Code, is to protect federal dollars. And the guidance of the Justice Department is, look, if this is more like a state issue, let the state handle it. Now, do you think that would apply here? Of course it would. It is inexcusable. It is on the barely, I mean, if it was 1 penny less, if it involved 1 penny less of $5,000, this would not be under federal jurisdiction at all. So why would the federal prosecutors dismiss Andrew Gillum's 17 counts today and still be hell-bent on this case under Section 666? Why is that? Do you ever get the feeling there's something going on and we're not in on it? I sure do. All right, I'm going to show you what the 11th Circuit that governs this district, the trial court that Finch is being retried in. I'm going to show you what they say about quid pro quo versus a wink and a nod. And I'm also going to show you what some of the other courts, the most recent opinion by the 5th Circuit Court of Appeals, why they say, no, it absolutely requires, I don't know, evidence, quid pro quo. I'm going to show you all of that in just a minute.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
All right, so this is really fascinating. This whole case is super fascinating. It involves, this is a Section 666 conviction that took place in 2000 under this district, under the 11th Circuit. And after the defendants were convicted, they were contractors and a county commissioner. It involved $3 billion of contracts. And the bribes were huge. A retirement home for the county commissioner. They were huge bribes, not a $5,000 check for a business loan. It's such a fascinating read. And in 2010, took that long, the 11th Circuit Appeals upheld the convictions. It's a lot of money, a lot of federal money, big bribes. But here's what the 11th Circuit said that governs this case. This is why this Circuit Court of Appeals does not require a quid pro quo. It says, in concluding, Section 666 does not require a specific quid pro quo. We align ourselves with the 6th and 7th Circuits. Okay, and then it gives the cases, stating that the text says nothing of a quid pro quo requirement to sustain a conviction, and while a quid pro quo of money, in other words, you do this for me, and then I'll do this for you. That's what that means. That's what bribery must have, except for this section in some circuits. For a specific legislative act is sufficient to violate section 666. And then it quotes the case. It's not necessary, and that an exchange of money for the official's influence was enough. It goes on to say, concluding that the corrupt intent in section 666 requires the government to prove a quid pro quo, but stating the quid pro quo requirement is satisfied so long as the evidence shows a course of conduct of favors and gifts flowing to a public official in exchange for a pattern of official actions favorable to the donor. The intended exchange in bribery can be this for these for these, and not just this for that. Okay, so the 11th Circuit upheld it in, if you want to look it up, it's an interesting read. It's a very interesting read. This is the United States versus McNair, U.S. v. McNair. Okay, and you'll see when look at the context here. These contractors and the county commissioner, again, they were convicted of public corruption, and they appealed here in the 11th Circuit. And here's what it says. The consolidated appeal arises from 5 bribery and public corruption cases relating to the $3 billion repair. See, this is usually applied to big money. Of government money, not the contractor's own money. And the rehabilitation of a sewer and wastewater treatment system in Jefferson County, Alabama. There were 2 county officials, 3 corporate contractors, 4 individuals who own these respective contractors. It's a really interesting read. All right, but that's the 11th Circuit says, we don't think section 666 requires a quid pro quo, but other circuits do. So why would they? What's their reasoning? Let's take a look. So let's take a look at the most recent one, which was last year, the 5th Circuit Court of Appeals. Let's see what they said. This will give you some really good reading. And if you just look up 5th Circuit Court of Appeals, section 666 decision, you'll find this. Here's what they said last year. Section 666 grew out of a circuit split over another law, the general bribery statute, 18 U.S. Code and Section 201, applied to public officials. Percolation of cases applying to the statute led courts to a problem. Does the term public official include state and local officials? This was prior to 1986. The Supreme Court granted certiorari, which I don't know if I'm even saying that right, but what that basically means is we will look at it and make a higher decision. We'll review it and make a higher decision in a case to resolve the split over this issue, and that was Dixon v. United States. But once it did, Congress enacted Section 666 to extend federal bribery prohibitions to bribes offered to state and local officials by agencies receiving federal funds. So at the same time the Supreme Court was reviewing it, Congress actually passed an act. Section 201 has 2 distinct subsections. Section B covers bribery, which requires a showing of that something of value was corruptly given, offered, or promised to a public official with the intent to influence an official act. Subsection C covers illegal gratuity. So this is the specific split. Some courts of appeals distinguish between illegal gratuity and bribery, rightfully so, and the 11th Circuit does not, the one governing this case, Finch. An illegal gratuity requires a showing that something of value was given, offered, or promised to a public official, not this for that, but for or because of any official act performed or to be performed by such public official. This is why they rewrote James Finch's indictment 4 times, because they did not have quid pro quo, and they had to go to this, the wink and the nod. When Congress passed and President Reagan signed what would become 18 U.S. Code Section 666, it had only one subsection. It criminalized something like what is in subsection C, the illegal gratuity provision. See, this again is the Fifth Circuit that says, it requires a quid pro quo. James Finch could not be prosecuted in that jurisdiction of the United States because it actually requires a quid pro quo for bribery. Because of the illegal gratuity provision with its for or because of language. 2 years later, Congress changed that provision by swapping out the for or because of language for language like what it used to say, which is the quid pro quo, the intent to influence verbiage, and it added the requirement that it be done corruptly, the giving of it be done corruptly. So the maximum time for a conviction under this Section 666 for federal officials is 10 years. For state it's not even for officials. For the person that's being charged with bribery or receiving the bribery is 10 years for the federal application and 5 years for the state application. So I want to sort of review this with you one more time in the bullet points, now that you've got a little bit of context. And you see that today, the U.S. Attorney's Office, U.S. Attorney Jason Cootie, dismissed Andrew Gillum's 17 counts, which are much more substantive and have much more evidence, so that they can focus this flimsy, not even applied in half the country to James Finch over a $5,000 check involving his own money, not even federal money. Something's going on here. Wouldn't you agree? All right, I'm going to go over those bullet points with you one more time so that you see this very clearly right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
It's a hot time in Florida, and my friend Ryan can make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
Okay, here's what you need to know. And I really tried to break this down so that it is super simple. As a matter of fact, you can screenshot these 6 or 7 bullet points. Just screenshot them. And then you will understand why this is outrageous. Look at this. U.S. Code, 18 U.S. Code, Section 666, targets political corruption in federally funded programs. And it extended the reach into state and local governments, especially for bribery and illegal gratuities. Federal jurisdiction kicks in when a state or local government receives at least $10,000 a year in a 1-year period, and when at least $5,000 is used to corruptly influence an official government act. 2 crucial governments must be met in order to get a conviction. The intent, you got to prove the intent to influence, which is very difficult, by the way. And also the giving of at least $5,000, at least, or it's not federal jurisdiction, be done corruptly. Those two have to be met, both of them. About half of the U.S. courts of appeals require quid pro quo for bribery conviction under code, it should say under section 666. The rest don't require quid pro quo for bribery. A wink and a nod is enough. James Finch is being retried in the Northern District of Florida, which falls under the 11th Circuit Court of Appeals, and that does not require a quid pro quo for conviction, which is why they wrote the fourth version of the indictment, so they could use this flimsy law that the Justice Department suggests they not use if the amount is so small that it should be under state prosecution. That's the Justice Department's recommendation to U.S. Attorney Jason Cootie. The whole purpose of Section 666 is to protect vast sums of federal money. We're not even talking about federal money. We're talking about Finch's own money. So the U.S. Attorney's Office is spending God knows how much federal money to convict a guy over the minimum $5,000 that they say he used to influence a former commissioner for a vote on the financing that was already voted on more than 6 months earlier. Are you with me? U.S. Attorney Jason Cootie rewrote the indictment against Finch for the third time, the fourth rewrite, or the fourth total, 3 rewrites, 4 total, in order to apply Section 666, since there was no good evidence of quid pro quo. So they're going for the wink and the nod. Final one. The $5,000 check that Finch wrote to former Commissioner Barnes is the lowest possible amount in order to fall under federal jurisdiction. That is incredible, is it not? All right, I've been wanting to share this with you because it seems complicated, but when you really break it down, which I've been trying to do for the past week, it's actually really pretty simple and pretty amazing, isn't it? All right, I'm going to read your comments in just a little bit. I want to thank, of course, the Unknown Patriot for your support and all of the sponsors for your support. And by the way, if you want to contribute to my efforts, my independent efforts, here's one way you can do it. It's like a tip at Patreon, patreon.com/Bernie Thompson. As little as $5 a month. It's easy. It's anonymous. And you can quit at any time. That's just one way. Best $5 a month you can spend on the internet. Nobody else is going to break the. You think WMBB is going to do this? Huey Lewis in the news? All right. Thank you for being with me, and I will see you again very soon.